For business law, any kind of business law, any law, the whole thing starts from the argument, right? So for example, for today's midterm exam, the fact is very simple. So you have 30 minutes to write it out. You only need to spend 1 minute, just copy from my questions. Miss Webster, a lady, went to a restaurant and ordered a clam chowder soup, okay? It's very, very ordinary life. This lady went to the restaurant and ordered a soup, fish soup. And however, this lady got hurt from a bone in the soup, okay? Got hurt, okay? Damaged, injured, because this lady claimed when she take this soup and there was a bone, fish bone in the soup and hurt her throat. So this very simple case went all the way to the court, and this lady asked for the recovery. So this is a fact pattern. So number one, so for your exam, for your homework, even for your final presentation, it's the same thing. You just lay out the facts pattern. So simple, right? A lady went to local restaurant, ordered a soup, a fish soup, and this lady claimed she got injured because she said there was a fish bone in the soup, so she got injury. Then she filed a lawsuit against this restaurant, asked for recovery. This is a facts pattern. This is it, right? Then next one, you need to lay out what is the issue. The issues here is breach of contract. Breach of contract. Of course, in the real life, you can have so many cause of action, right? And bodily injury is another cause of action. But for this facts pattern, this lady filed a lawsuit not because another thing is, she said this restaurant breached contract. Because there was a contract, right? I'm a customer, you are the seller, you sold me something, at least you need to warranty this kind of thing is safe. At least, I don't mind whether or not it's delicious. But at least you need to maintain the soup by itself must be safe, right? And I got injured from your product, so at least I said, you are a merchant, you breach your contract. So I asked for the damages from breach of contract. So the basic issue here, for example, is whether or not, or how, okay, the restaurant to fulfill its duty from the contract. So what is the minimum standard? What's the standard? The court gonna to see what's the standard. If the restaurant already fulfilled the very basic standard procedure to cook this soup, making sure nothing there, as long as the restaurant can prove from its regular process, what is the process this restaurant to prepare this soup. If this process can be proved in the court, and if this process can meet the standard of industry, if every other restaurant is doing the same thing, even after this procedure, if any other thing happen, then the court need to make a decision whether or not this restaurant already fulfilled. So right now the issue is, that in this case, we know the facts pattern, right? Very easy. The issue here is whether or not the restaurant owner breached the contract. This is general speaking. And more specifically is whether or not the restaurant chef or restaurant owner already fulfilled their obligation to prepare the food. Whether or not their standard process to prepare the food already meet or at least meet the standard of the industry. Then this is number two. Number three, you need to find out the authority. And in your exam, you can say, okay, according to the case, what year, what kind of case, and in that case, the judge or the court already find This is the standard process. This is the standard for the restaurant business. So this is the authority. This authority being adopted by another court already, in another decision already, in another cases already. So this is my authority. So if you choose the side to defend for the restaurant, you say, oh, this is authority adopted by another cases. So this is standard. Or you choose, you take a side for the customer, the plaintiff in this case, Ms. Webster, you say, no, this is standard. This is the authority adopted by this case. So the standard must be very high. And then, so when you choose the size, you have the authority. I provide you authority in the case. Then there are only 3 pages, okay? For my questions, it's only 4 lines, but there are only 3 pages. So you just made a decision. Don't take too many time to decide which side you gotta take, okay? Don't sit in there for 30 minutes and say, I want to defend for the restaurant. No, I want to represent Mrs. Webster. Don't waste your time, okay? Each side is okay. I think I provide sufficient authority for each side. Don't waste your time. You just pick out the side and pick out the authorities. This is the number 3, authorities. So you probably just pick out like a 3, 4, even 5, not more than 5 authorities. Probably 3 is enough. Say, okay, this is the standard choose by this case. So for my client restaurant, this is the standard. Okay. Then number 4, you need to convince me, convince the juror, convince the judge. Say, hey, in this case, my client restaurant proved in the court they already fulfill their practice already, and this is their standard procedure to prepare the food. And this is not what I say. This has been proven in the court already. So apply my case to my authority. My client already fulfill their obligation. So even though the bad thing happened, but this is totally accident, and at least for breach of contract, my client did not breach the contract. My client already fulfilled his obligation. Then number 5, finally, only 1 sentence, say, based on the information, based on the argument I state here, my client is not obligated, is not liable for Ms. Webb's injury. Or upside down, you say, I represent Ms. Webster, and because the restaurant did not fulfill its duty obligation, so my clients deserve to get the recovery. So 5 steps, okay? Facts pattern, you can go ahead, just copy down from my questions. Spend 36 seconds, okay? 1 minute. Copy down. These are facts. Number 2, issue. What is the issue here? The issue is here whether or not the restaurant's breach is obligation from the contract. Number 2, right? Issue. What is the issues here? Very simple. Number 3, then you need to pick out probably 3 authorities for your side. You don't need to care about the other side, right? And number 4, more important, reasoning. Why your client already meet the authorities you choose. Why? You need to state it. You need to say, okay, this thing has been proven in the court. My client already meet or not meet or whatever. And number 5 is very easy. 1 sentence based on the argument I stated here above. My client is not liable, or my client is entitled to get a recovery. So 5 steps. All right. So same thing for your homework, for your final presentation. I think it's getting to the end of the semester. So I think I appreciate Eugene's questions. If you only own 1 share of the stock, and that's the issue, right? That's the argument, right? Only own one issue, right? One share of the stock. Are you entitled to purchase the life insurance and protect the CEO of the company? I would say probably the answer is no. I have not done any research yet, but from my guess, I think the answer maybe no. But if you really argue, yes, you are entitled to, Because what? Because the total share for the company only 10 shares, for example, then it change everything, right? If the whole company only issue only total 10 shares and you already own 1 share, this is 10%. It's good enough, right? Anyway, this is a good argument, right? Insurance. Any other thought about insurance?
Just the contract has to consider the insured